As is usually the case in such situations, Justice Roberts not only went into great detail regarding the question of whether or not SFFA had standing to bring the case, but into the history of the court's jurisprudence regarding the 14th Amendment as well. In his review of court precedent, Chief Justice Roberts noted, then, in Grutter v. Bollinger, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. However, the Grutter court did not expect this to be a permanent situation. Grutter thus concluded with the following caution. It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. Chief Justice Roberts pointed out that previous courts' expectations were flawed. 20 years later, no end is in sight. Harvard's view about when race-based admissions will end doesn't have a date on it. Neither does UNC's. Yet both insist the use of race in their admissions programs must continue. Chief Justice Roberts went on to say, because racial discrimination is invidious in all contexts, we have required that universities operate their race-based admissions program in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. Classifying and assigning students based on their race requires more than an amorphous end to justify it. Respondents have fallen short of satisfying that burden. Once again, we see the unconstitutional and destructive use of strict scrutiny used to subvert the Constitution of the United States and infringe on the rights of the people. Chief Justice Roberts points out that the Supreme Court has and would continue to allow racist admissions programs in public schools and universities as long as they could convince the court that there was a government interest sufficient to overrule the supreme law of the land.